Okay, I've got the pleasure of introducing our next speaker. Mark Cady is married. He has 2 children. He has 3 grandchildren. He's a graduate of Drake University in 1975. He graduated from Drake Law School in 1978. He was appointed a district court judge in Iowa in 1986, and then in 1994, he was appointed to the Iowa Court of Appeals. He's been a member of the Iowa Supreme Court since 1998. He's been Chief Justice of the Iowa Supreme Court since 2010. His current term expires in 2024, and we hope that you serve out your current term and perhaps another. Chief Justice Cady spoke here about 7 years ago. It was an honor to have him then. It was a very enlightening presentation about Iowa and its role in civil rights over the years. And we understand he's got another interesting topic to talk to us about today. So it's my great pleasure to introduce Chief Justice of the Iowa Supreme Court, Mark Cady.
Thank you very much for that warm introduction. It is good to be with you again. I've become good friends with your chief, Mike Havigan. I hold him in great respect and admiration. And I have many friends that are among your bar and friends in the community. So I feel a little bit at home. But I should tell you that I still haven't gotten over the fact that Creighton left the Missouri Valley and my beloved Drake Bulldogs, but I'm working on that. Let me begin by explaining why I'm talking to you this afternoon about implicit bias. As judges and lawyers, our potential to contribute to the law is not just confined by the work on the cases that we pursue and the decisions that result from those cases, but we can also achieve justice by giving voice to injustice when we see it, and by improving the process of justice when we have an opportunity to do that. So when we gather at times like this time, it is helpful to talk and to think about the obstacles that do interfere with the essential objectives of our justice system, to try to discover ways to continuously improve to better meet these objectives, or to become, in the words of our founders, a more perfect union. It was 7 years ago that I spoke to you about the importance of fair and impartial courts and the need to protect courts from retribution for unpopular decisions. These remarks were in response to the public backlash and the 2009 decision that recognized the constitutional rights to same-sex marriage. Attacks that seek to undermine our courts and our justice system continue today, and your continued support is still needed today, if not more than ever. But it is today that I want to talk to you about something else that can adversely affect our fundamental values and our process of justice, and that is implicit bias. Now, any form of bias interferes with justice. I think we can understand that. It is not who we are, and implicit bias is included. So, we must work to identify implicit bias and remove it from our justice system and society, just as we have done with explicit bias. This is, I believe, our time to confront first give you some background information and some understanding of how implicit bias works and how it can exist. Now, the advancement in the human sciences in recent years have identified the existence of implicit bias in all of us. It is, simply put, the defense mechanism of our brain that helps us to automatically and quickly protect ourselves from perceived dangers and to respond to other events in life. It is the mind's way of making automatic and unconscious associations between two concepts. And it's based upon a lifetime of associations that unconsciously work throughout the day in each one of us to unconsciously direct our thinking, built upon preconceived perceptions, stereotypes, and even fears. Simply put, these biases come from the way our brain works. Now, basically, the human brain has developed over time, a lot of time, from the center out. The part of the brain that separates humans from all the other animals on the earth is the outer layer, the newest part of our brain. In particular, it's the frontal cortex that makes us uniquely human. It's the region of the brain that gives us our sense of pleasure and other human emotions and allows us to reason and to use this reasoning to make measured decisions, to do the right thing. But it's the oldest part of our brain, the part we actually share with other animals, that's at the center and the core of our brain. And it's not only the oldest part, but it's the most powerful part. And it remains the most powerful part today. It gives us our instinctive behavior. And we'll always win out or overpower that newer part of our brain. Part of the brain that wants to stop and to reason and to think things through. It means our instincts have a tendency to win out in life. And much of our behavior over each day that we live becomes automatic or instinctive. This, of course, as I've said, has mainly been a good thing. It's allowed us to survive over millions of years. But this science also explains why many people, for instance, react immediately at the sight of a spider, or while some people seem to instinctively want to stop and buy sweet corn at a roadside stand. Some people instinctively fear all spiders, and they assume that roadside vegetables are fresher. These assumptions that spiders bite and produce is fresher are a form of implicit bias. And we act on this bias without even thinking, more importantly, whether they are actually true. And there lies the rub. In truth, spiders are not aggressive, and most could not even break the skin if they tried to bite. And likewise, roadside produce is not fresher than stored produce. But conditioning has occurred in the brain, and the conduct based upon that conditioning becomes our instinct. And so it is these assumptions and how our brain uses them to limit our thinking and produce instinctive actions and deep-seated beliefs is what I want to examine with you today. But in the context of our legal profession and our by allowing us to instinctively and quickly avoid danger or perceived danger. It can threaten justice when it takes on the form of unconscious negative associations with certain identities, such as race or gender or certain beliefs, and then associates those identities and beliefs with some undesirable attribute. For example, crime or violence or weakness in people. We instinctively develop a bias even though the attribution may not be true. An animal shelter will tell you that the hardest dog to put up for adoption is a black dog, based on an implicit bias that black dogs are mean and aggressive. And even Jesse Jackson tells of a story of experiencing sudden sensation of fear while walking in a Chicago neighborhood at night and hearing footsteps approaching from behind, and immediately feeling relief upon turning to see that that person is a white person. Most likely we have all had these experiences. This is implicit bias. But the reason I want to talk to you about this afternoon is simple. We are a justice system, and we must do everything that we can to operate fairly and impartially. As a legal profession, as lawyers and judges, we have done a good job of addressing the implicit bias or the explicit bias in the law. But we now must address the implicit bias that is embedded within us, which can work in so many ways, countless ways throughout the day and throughout our legal system, including the decisions that are made in our legal system. A 2000 report revealed that African Americans who have never been sentenced to prison before are 6 times more likely than Caucasians to be sentenced to prison. A 2000 report revealed that African Americans account for 16% of all youth, but 28% of juvenile arrests, 35% of children waived into adult court, and 58% of all youth sent to prison. In Iowa today, African Americans are 8 times more likely to be arrested for drugs and 8 times more likely to be sentenced for that arrest for drugs, even though African Americans and Caucasians use and possess drugs at the same proportionate rate. 3 years ago in Davenport, Iowa, a majority of the high school students referred to juvenile court for criminal acts were African American students, even though the African American population in Davenport is less than 5%. In Washington State, a report found that African Americans and Caucasians were routinely described differently in sentencing reports. African Americans were typically viewed as committing crimes due to personal flaws, such as disrespect or incorrigibility. Caucasians are routinely described as committing crimes based on family issues or family dynamics. These factors then affect the sentence imposed. The same type of implicit bias has been recognized in criminal prosecutions. African Americans tend to be perceived as drug dealers, while Caucasians tend to be viewed as kids experiencing with drugs or selling to friends. Again, these perceptions affect the severity of the sentence. But the concern of the criminal justice system extends beyond racial bias. One recent empirical study showed that the male justices on the United States Supreme Court interrupt the female justices during oral argument 3 times more often than they interrupt the other male justices. While this treatment is consistent with society overall, it shows that even the most powerful women in our country are not immune. Research informs us that these interruptions are, in general, a result of attempts at dominance. And it works, even with the justices on the United States Supreme Court. And it even includes dominance by male advocates standing before that court who interrupt the female justices on the court far more often than the male justices. The interruptions are instinctive. We've all done it in the courtroom, and they are a form of implicit bias. In truth, the research shows that women in general do get talked over much more often than men, and it's largely due to this unconscious bias, this long-standing belief in dominance. Its effect on justice? Well, when a female justice is interrupted, the concern is that her thoughts about the case that she thought to express can be left unexpressed. And she can then have perhaps less influence on the outcome of the case. But let me give you a more concrete example of how it can be played out. In 1911, in a case in Iowa called In Re Carriager, the Iowa Supreme Court rejected the challenge of a female pharmacist to a state statute that prohibited women pharmacists from dispensing drugs that contained alcohol or alcoholic products. The court found, this was over 100 years ago, the court found that a rational reason existed for this disparate treatment on the basis that there were simply some jobs in life that men were better suited at doing than women. And selling alcoholic products was one. In its decision, the court revealed its implicit bias, and it failed to appreciate the truth of her claim, the claim of the pharmacist, based upon the legal argument that she made and the evidence that was introduced at trial, as well as the growing suffrage movement at the time and so much else that was occurring at that time. Instead, the court relied on the old part of its brain, its instinctive reaction, its instinctive view of male dominance. Justice was not advanced in Iowa on that day in 1911. Implicit bias can also be embedded in legal advocacy itself, almost amusingly, and in the judgments made by attorneys in the course of advocacy. Very recently, a federal judge in New York denied a motion to dismiss a workplace discrimination lawsuit based upon the defense attorney's argument that the supervisor's use of the N-word was just a bad joke and not discriminatory animus. But a bad joke. A bad joke can also be a form of implicit bias with the same effects on others as explicit bias. Because what is perceived as a joke to one person can be very offensive to another who is not like that person. In the same way, a recent survey of Iowa lawyers revealed that 84% of Iowa of women lawyers in Iowa had witnessed or have been a victim of gender discrimination or harassment in the workplace in the last 5 years, while only 34% of male lawyers in our state reported that they had ever witnessed such conduct or were aware of it. 84% versus 34%. Again, a form of implicit bias was at work, and it is preventing men from even seeing or realizing what they are doing or may be doing is demeaning to women. That is the very nature of implicit bias. The instinctive reaction of the brain will just continue to guide us until those perceptions upon which they are based are changed by what we learn over time, or by the understanding that we gain over time by purposely taking time to see and appreciate the perspectives of others. So just think for a minute. Just think for a minute about our legal system and the array of discretionary decisions that are made throughout this legal system, and the potential for implicit bias to flourish undetected and unexamined within those decisions at all levels. All of this is a huge potential problem for a justice system, and it is going to take much time to sort out and resolve. But I'm talking about it because we do need to begin. We need to begin by being more willing to talk about it, and by being open to the science of how and why we process information and think and make our decisions. And we need to remember as well that we do our very best work as judges and lawyers when we follow the data, when we follow the evidence, when we follow the science, and react from what we learn. In 1967, in Ray Galt, the United States Supreme Court totally changed our juvenile justice system and our juvenile law. A very historic moment. But it was not done just because the court decided to change the law. The court was driven by the evidence. The court was driven by the science. They used the science that informed them, science brought in to the court by the lawyers, that showed them that kids are much more accepting of efforts to rehabilitate and reform when the process of justice is viewed as fair. And in response to that, the court overhauled the juvenile justice system to make it fair and in turn promote greater opportunities for rehabilitation. In 2012, in Miller versus Alabama, the United States Supreme Court held that the mandatory sentencing of juveniles to life without parole was no longer acceptable under the cruel and unusual punishment clause. They did this almost solely because of the science, what we had been understanding and learning, that informed the court that the juvenile brain is not fully developed until far after, so far later in life than we ever believed. And Iowa's same-sex marriage decision in 2009, we did not recognize that constitutional right to equality marriage based upon our beliefs in equality, but on the science of sexual orientation and the evidence, for example, that children grow up the same, just as if they were with a mom and a dad, or two moms or two dads. There made no difference. In other words, the reasons to deny marriage were not supported by what we had learned. once again, that explains our continued struggle to deliver on our nation's promise of equality. We need to identify how implicit bias operates and how it can be done what can be done to minimize its impact on our pursuit of justice. And it is no easy task. I have had my own personal experiences in discussing implicit bias with people saying to me that such a discussion is demeaning to people, to law enforcement and other people, including judges, because I am in effect accusing them of being biased, of being prejudiced, and that we should be talking less about this. The truth is just the opposite. We should be talking more about implicit bias in this profession. We need to talk more about implicit bias, but do it in a way that's thoughtful, that is contemplative, that is respectful. We need to discuss racial disparities in our society without feeling that it's a put-down towards anyone or an insult to anyone's character. It is not any of these things, because we must remember that we are talking about our brain and how our brain works unconsciously and how it stores our past unconsciously and how it uses it instinctively. And we have to remember that that old part of the brain is always going to win out over the human ability to reason unless we stop. So, we must be careful to accept that implicit bias is not racism, it is not bigotry, it is instinctive, it is unconscious, it is unconscious thinking, and it can even involve thinking that runs contrary to our stated values, but it nevertheless results in unintended bias. And this, of course, reveals the complexity of implicit bias. It also reveals why it will take time and much effort to understand and to compensate. But to do this, we do have to be able to talk about it without being negative. We need to talk about it without being critical of others. And we need to talk to be understood, to understand so that we can act more in ways that are consistent with our constitutional values. And I'm fearful that if we don't stand up and talk about it, inequity in our justice system only threatens to remain to be hidden and only gain strength and result in prejudice and bias. So, let me tell you about one effort currently underway as an example of what can be done to address implicit bias and racial disproportionality. This effort shows that solutions can sometimes be as simple as minimizing the consequences of our brain. I told you earlier about the racial disproportionality of youth referred to the juvenile justice system by the Davenport school system in Iowa. Now, the consequences of this referral is not just the disproportionate number of African American students entering our criminal justice system, but I think we all can appreciate that the greater consequences concern what follows from that referral. Because we know that when juvenile offenders find their way into our criminal justice system, too many of those offenders never get out. And too many of them are then hindered in life by a criminal record. And too many of them grow up with fewer opportunities in life. And these opportunities are, in turn, shared disproportionately. on research from Georgetown University, Iowa established a new process of dealing with school referrals. Instead of redirecting juvenile offenders into our court system upon such referrals, we've created a juvenile diversion court for first-time misdemeanor offenders. This diversion court places the offenders into a community program, and the court then works alongside a team from the school, the police, community providers, and parents to provide rehabilitative services. And the results of this process could not be more promising. In 2015, the Davenport school system and the Davenport police diverted nearly all juvenile offenders charged with misdemeanor crimes into this community program, and the recidivism rate was only 16%. In 2016, the next year, every youth in the city charged with a misdemeanor was diverted into this program, and only 7% reoffended. This community program addresses the needs of the offenders by bringing families into the process to interact with their children, and by working with the offenders to build on their strengths and to give new insights to prevent mistakes. This new understanding is being achieved, and criminal records are being avoided. Now, this new approach is an entirely different paradigm shift that utilizes the science of adolescent brain development in a positive way, and is showing signs of reducing racial disparity formerly associated with the treatment of juvenile offenders. And importantly, drawing from my comments about in-rate vote, juveniles see it as fair. And instead of giving them criminal records, we are giving them opportunities. And at the same time, it's important to see that the Davenport experience as an example of how to talk about implicit bias and how to deal with the data that supports racial disparities. When faced with the data in Davenport, the disproportionate number of referrals of African American students, the school system and the police department and the community leaders did not seek to deny that implicit bias may be working in their decisions to refer kids into the criminal justice system. Instead, they were brave enough to decide to work to fix the problem, to eliminate the consequences. And what they are doing today is becoming a model for other communities in our state. And yes, fewer African American students are now being referred into our court system. But there is so much more that needs to be done. But there are so many more opportunities out there to discover. Perhaps it's time for our state, and maybe yours, to form a broader coalition or assemble a task force to discuss the broader constructive approaches that will lie in our future. But I believe that whatever the next step may be, it could be the greatest opportunity of our profession has ever had to advance justice. The good news in all of this is that justice is a belief that is a part of every one of us. It's a part of you in the same way that it is a part of me. You feel it as I do. We want it for ourselves, and we want it for other people. And it, too, this sense of justice, too, comes from a part of our brain, that region of our brain that's responsible for the feeling of reward and the feeling of pleasure. And it means that our instinctive pleasures in life is against equality. Our implicit justice that we all feel is there for us to work for equality. This must now rely upon and use to overcome the implicit biases that interfere with our collective belief in equal justice for all. In Iowa, all judges in our state have now received training on implicit bias, and we are beginning to undergo another round of training. We are driven to become better decision makers, more fair decision makers, and we know that this can be done by understanding implicit bias and by understanding the perspectives and viewpoints of litigants free and unchained from our implicit bias that could interfere with that understanding. But this does not end with judges. Good lawyering requires an understanding of the perspectives and the arguments of opposing counsel, free from implicit bias that may hinder the ability to see that understanding. Juries, too, need to make decisions free from implicit bias. For that reason, the Iowa Supreme Court has encouraged the judges of our state to instruct juries on implicit bias, to sensitize them to its existence. And law enforcement will benefit from understanding how implicit bias can interfere with the work that they do. But there's something in it for all of us, and we'll all benefit from it. So, this then gets back to spiders and roadside vegetable stands. You see, some common judgments in life that are not based on truth are harmless. But never within a system of justice. We will move closer to becoming that more perfect union that we strive to be when we can change the way implicit bias operates or may be operating within our criminal system and within our justice system. In his second State of the Union address on January 11, 1962, President John Fitzgerald Kennedy said that every area of trouble gives out a ray of hope, and one unchangeable certainty is that nothing is certain and nothing is unchangeable. By continuing to work together and by continuing to come together on days like this to talk about implicit bias, we can be a part of the change needed to give greater meaning to justice for all. From my perspective, from my viewpoint, I think the ray of hope today has never been brighter, and our opportunity has never been stronger. So let us use this light to make justice more complete. Thank you so much for the opportunity.